It's long been established that our patent laws are primarily intended to encourage progress related to science and useful arts. To that end, inventors are afforded certain exclusive rights for disclosing their inventions. The 1917 Supreme Court case of Motion Picture Patents Company versus Universal Film Manufacturing Company, however, explores one patent holder's attempt to expand those exclusive rights in the context of a very young movie industry. Motion Picture Patents Company held the patent to a film threading mechanism for theater film projectors and granted a license to a manufacturing company. The license authorized the manufacture and sale of motion picture machines that incorporated the mechanism but required the manufacturer to affix a plate to the machines that included an express restriction on the use of the machines. Specifically, the restriction stated that the machines could be used only with films leased from one of Motion Picture's licensees, and that use of other films on the machine would constitute infringement. Universal Film Manufacturing Company supplied, to end users of the machines, films from other sources that didn't satisfy the restriction, and those films were used in the machines, also contrary to the express restriction. Motion Picture brought suit against Universal and others for patent infringement in district court. The court held that the restriction was invalid. The Circuit Court of Appeals affirmed, and the Supreme Court agreed to review the case.